afternoon. You can be seated. The matter before the court is York 25416, Judith Andrews versus the Town of Kittery et al. I see counsel are present. I'm assuming you're ready to proceed. We are being streamed on the web, both by audio and by video. I would ask counsel who will be arguing in this matter to identify themselves by saying their names for the record together with the party you represent before we begin the argument.
Sean Turley on behalf of the appellant, Judith Andrews.
For the appellee, Town of Kittery.
Tom Faderly for Appellee, Party in Interest, Ann and Chip Andrews.
Thank you. And Attorney Turley, if you're ready to proceed, we'd be happy to hear your argument here today.
Good afternoon, Your Honors. May it please the court. This case is an appeal of a decision by the Planning Board for the Town of Kittery to approve a subdivision application submitted by the parties in interest, Chip and Ann Andrews. The grounds for this appeal is the fatal legal error made by the board when it purported to waive 3 ordinance standards that apply to all Class 3 streets in the town, including the proposed Acorn Lane. Because only the town's Board of Appeals has the authority to provide relief from ordinance standards of general applicability, like these standards, in the form of a variance, the board's decision was unlawful and must be vacated. I'd like to use my time to talk about some of the issues, put some of the issues presented this appeal in context. So under our laws, municipal corporations are creatures of statute with no inherent authority. The authority they have is what's been expressly vested in them by the legislature and the powers arising by necessary implication of that grant of authority. One of the areas in which the legislature has decided to further limit the power of municipal corporations is under the land use regulation statute. Part of that statute, section 4353 of Title 30A, expressly and exclusively vests in boards of appeals the authority to provide relief from ordinance standards of general applicability by granting variances. As this court established in Perkins v. Town of Ogunquit, that vesting of authority in boards of appeals impliedly and necessarily preempts planning boards from exercising that power. Therefore, municipalities cannot, under the guise of their home rule authority, grant to their planning boards the power to waive ordinance standards that apply town-wide. That is the basis court's holding in York v. Town of Ogunquit, where the court found that the planning board had acted beyond its authority when it purported to waive a width requirement that applied to all collector streets in the town. And that error in York is the same error made in this case. The street standards at issue in this case are contained in a table that's incorporated by reference into the town's general performance.
The green light is on.
Thank you, Your Honor.
So I'd like to focus on the statutes
Absolutely.
for a minute. Only a Board of Appeals can grant a deviation from a zoning ordinance, correct?
Word that language, Your Honor.
So a zoning ordinance is a type of land use ordinance, correct?
The only reason I'm pausing is I think it's a bit unclear if those are distinct. I would say that a zoning ordinance regulates land, and so do land use ordinances. And sometimes these are codified as site plan ordinances or general performance standards, or however, they could be separate ordinances. It could be all one part of a single ordinance.
Well, let's go back to the statute. The statute defines what a zoning ordinance is, right?
It does for the purposes of that statute, yes.
Well,
Well, I would say, Your Honor, that this court's decision in Worcester v. Town of Mount Desert would suggest that the jurisdiction of boards of appeals is beyond simply pure zoning ordinances, and that it extends also to land use ordinances. And so
you're saying that there may be things outside the zoning ordinance itself that still a planning board can't waive?
I'm saying that in York v. Town of Ogunquit, this court said, and this is same in Sawyer v. Town of Cape Elizabeth, that planning boards can certainly waive ordinance standards that apply exclusively to subdivisions. That's lawful, that's fine. But when you venture into the other parts of the ordinance, both that apply generally and also that divide divide municipalities into districts, that's where their waiver authority ends.
There were
in York versus Town of Ogunquit, there are actually 5 items in dispute, and we upheld the planning board's authority with respect to 4 of those.
Correct, Your Honor.
And not with respect to the 5th. And it seems to me that the matter in issue here is closer in kind to the 4 that we upheld there.
So, Your Honor, the standard in York that the court found to be unlawfully waived applied to all collector streets. And the decision doesn't say all collector streets in this district, in that district. It just applied, generally speaking, to all collector streets. Here you have a street standard that applies to all Class 3 streets, and it's codified not in the subdivision ordinance, but rather in the general performance standards. And I'd add, the court came to that conclusion in York despite the fact that that very standard appeared also in the subdivision ordinance. It said that's not enough. Since it applied broadly, we can't waive it.
I'd like to shift the focus for a moment.
Sure, Your Honor.
You agree that if there's a conflict between statute and ordinance, that statute prevails?
Yes, Your Honor.
In Title 30A, Section 4482A, a party may file an appeal with the Superior Court of a municipal land use decision subject to this section that is a final decision within 30 days of the date of the vote. This appeal was not filed within 30 days of the vote. It was filed on the 46th day, which happened to be a Monday, which then arguably puts you under the 45-day rule, but doesn't the statute override the ordinance in terms of the time for an appeal? Do we have jurisdiction to hear this case?
I think you do, Your Honor. So part of the issue here was when they actually voted on October 24th, and there was actually a discussion between us and the town regarding the delay in getting the signed findings of fact that evidence their decision. Under Rule 80B, if there's a required signed findings, it runs from that date, not from the date of the vote. I appreciate that.
Wait. You said that 80B says it's the date of a signed and not the vote?
Sorry, Your Honor. I'm saying that under Rule 80B, there's a 3-step process for determining the deadline. If there's no written decision requirement, it's from the date of the vote. If there's a written decision requirement, it's from the date of the written decision. If there's a delivery of the written
Where
decision...
does it say that in Rule 80B?
In Part A.
Does it say the clock starts on the date of the written decision? Well, go on.
Well, let me ask you this. Would you agree that if we were to determine that 4482A applies, and the requirement there is that the appeal must be filed within 30 days of the date of the vote, that we do not have jurisdiction to entertain this appeal?
I'm not sure of that, Your Honor, because again, this is an appeal of subdivision approval under Title 30, the subdivision statute in 4401 et sec. So I think in passing that legislation regarding imposing a statutory deadline, it was between certain types of land use decisions, I believe, based on their significance. So I can't say, having not seen that argument raised by either of the parties in the case, that we are under the statute you're referencing as opposed to part of the subdivision statute, as that is the approval that was offered in the case.
But you understand that timeliness of an appeal is jurisdictional, so regardless of whether it's been raised by any party, we may need to
Absolutely,
address
Your
it.
Honor. I'm happy to answer these questions regarding it.
I'm looking at the rule, and I think that the part about the date is when no time limit is specified by statute. And I think Justice Douglas's question was suggesting that there is a time limit specified by statute.
I take your point, Your Honor. Seeing no further questions.
Well, I guess, let's assume that the statute does say 30 days.
Sure.
How would this be timely, or how is it not untimely?
Your Honor, I will fully admit to not having reviewed in preparation for this hearing the kind of timeline between the approval on October 24th and when the appeal was filed.
Well, one of the things that might have confused you is that the written order said, but the town told you you had 45 days.
Right.
Do you think that that might be an issue in determining what the clock should be for?
Well, Thank you, Your Honor. I mean, I would certainly say, as this court has spent a great deal of time recently enunciating the good cause exception, when put on notice, as my client was, of having a deadline of 45 days and acting within that 45 days, granted, as you said, including a weekend day, that would be perceived as timely as to the town, and that was proper notice to them of when they should file their appeal. It's a bit strange for a town to be able to escape potential challenge by advising citizens they have a certain date to appeal by, but then falling back on the fact that the statute contradicts it.
But it's also an odd situation when you have an ordinance that says you have 45 days, and you have the town telling you it's 45 days, but you have a statute saying it's 30 days, and if we don't follow the statute and we say, well, it's okay because the town said it was 45 days, isn't that superseding the statute, and can we do that?
Well, as I said, Your Honor, having not looked at exactly how the appeals deadlines work under the subdivision statute, I do not want to appear to be conceding that the statute referenced by Justice Douglas is binding and therefore set as 30-day deadline. So setting that aside, I agree that it puts the court in a weird spot, but given that the purpose of the ordinance is to correctly and lawfully advise applicants or appellants of the date by which they have to file an appeal, I would think that has a bearing. Otherwise, as you would note, it could be possible that a town tells an appellant you have 45 days, but they may only have 5 or 10, and they simply miss the deadline. They don't know they need to even try to achieve any type of good cause exception, and they're stuck, which, again, I can't think would be what the court would want to endorse or incentivize.
Let me change the focus once again.
Sure.
Putting aside the question of whether the planning board has authority to do it, was the planning board's action consistent with the ordinance? With the ordinance?
In what sense, Your Honor?
Well, they are given authority under 16.87 to make waivers.
You are correct, Your Honor. So no part of this appeal challenges the sufficiency of the findings on the waiver, or that there wasn't sufficient, what I believe uses the term special circumstances. That is not at issue in the appeal. It is not whether or not they followed the ordinance, it's whether or not they even had the authority under the ordinance to act.
Okay, thank you.
Go ahead.
Well, do you agree that if we just looked at the statutory definition of a zoning ordinance, this street standard doesn't fall within that definition?
If I only looked at that definition, yes, of course. I mean, I think it does say that zoning ordinances writ large, or very specifically, are things that divide towns into districts. But this court has clearly said in Worcester that when it comes to the Board of Appeals jurisdiction, it extends not only to zoning regulations, but also to land use regulations. It rejected this idea that that distinction is relevant when it comes to the jurisdiction of the Board of Appeals. Thank you, Your Honors.
And Attorney Front.
Good afternoon. Am I ready to go? Thank you. Good afternoon. May it please the court. Cameron Ferrante for the Appellee Town of Kittery. The issue before the court today is really just whether or not the mere location of a performance standard within a land use ordinance is sufficient to override municipalities' home rule authority. So, as the court's aware, municipalities, including the town of Kittery, have broad home rule authority under the Constitution and statute that can really only be limited by express statutory language or where there's a conflict or frustration of purpose of state law. Here, the town validly exercised that authority. It adopted its land use and development code, which incorporates both land use, zoning provisions, site plan and subdivision review processes, and generally applicable performance standards, including the street standards that are the focus of this appeal. The town further exercised that authority validly when it granted its planning board the authority to waive the application of certain performance standards subject to certain conditions in the context of site plan and subdivision review. That waiver authority, in this case, is not expressly or impliedly limited by Title 30A, Section 4353. The street standards here are in the nature of subdivision standards and are not zoning, as the court seems to have noted. The street standards are technical design standards. They're functionally, there's no difference across zones. There's nothing within the zoning provisions of the Land Use and Development Code that mandate compliance with the street standards within a particular zone. And functionally, they really only ever come under review or application before the planning board in the context of site plan and subdivision review. And for those reasons, I think it's proper for the town and for this court to consider them in the nature of subdivision standards that have historically been deemed waivable by the planning board without violating Section 4353. What the street standards aren't is zoning. They don't involve any division of the town into different, street categories or anything like that. They don't fall within the applicable definition under Title 30A, Section 4301. And Section 4353 has never been interpreted to extend the Board of Appeals' exclusive variance authority to generally applicable performance standards like the street standards in this case, and I would urge the court not to do so today. The appellant's case here rests primarily on a misreading or a unnecessary extension of Perkins, York, and Sawyer that both limit the planning board's authority to waive generally applicable ordinance standards and also expand a zoning board of appeals exclusive variance authority to cover generally applicable ordinance standards. Here, I don't think there's any conflict or usurpation of that exclusive authority of zoning boards of appeal.
What are we supposed to do with the fact that the town said they had 45 days and the statute says 30?
I think that is the court's prerogative. At this point, I would not feel comfortable arguing against jurisdiction where the town instructed the appellant to file an appeal within 45 days, notwithstanding the appellant's responsibility for, being aware of the law.
So it's in two different places.
Yes.
One is in the specific order that was issued.
Correct.
Which is presumably because the ordinance itself says 45 days. Perhaps an ordinance revision might be.
I was going to say, we assume you're going to run back to the town of Kittery. and
Perhaps
change
an
your
ordinance revision might be in question,
Okay.
depending on the court's determination here today, perhaps more than one, but hopefully.
All right, and on the front of the merits, if I was going to sum up what I think you've just said, you're saying, look at the statute. The statute has a pretty narrow definition of a zoning ordinance, and this doesn't fall within it. And there's nothing in the case law that says you expand beyond zoning ordinances to other types of land use. Now your colleague has said you do if you look at our case law. So what's in response to that argument?
So I don't think if you're talking about the exclusive authority or of the Board of Appeals to grant variances, that you would expand beyond zoning. There's limited instances, including in the town of Worcester case, where the court determined that a zoning provision of a generally applicable ordinance was subject to a variance review. But I don't think it would be appropriate to take a broad spectrum land use ordinance and impute into that exercise of municipal home rule authority a restriction on the ability to grant a waiver authority or modification element to a planning board. I don't think the mere fact that this court has restricted the planning board's authority in situations in which a grant of a waiver circumvents or contradicts a specific zoning provision means that the Board of Appeals can then go out and...
Well, setbacks are usually considered within the zoning ordinance, right?
That's correct.
So what's the difference between a setback and a street length or a street width?
I think the difference between a setback is that it's intended to govern, distance
It's a
between
dimensional
properties.
standard, right?
It is a dimensional standard. It's also a standard that is historically and contextually sort of like a core zoning standard. So I'd say setbacks, height, like frontage, those types of requirements have pretty much always been referred to as, sort of core zoning elements, dimensional standards.
Is that
Here-
what the test should be? Is it a core zoning standard?
I think I would hesitate to say a core zone, like that should be the judicial test that's applied here. I'm just speaking broadly about the court's prior holdings. I think the distinction between, a setback and a street standard is that the function of the street standard is to ensure a safe, passable street, so that town emergency equipment and other vehicles can pass over it, that there's adequate turning radiuses, things like that. And that's the reason for the limitation on the planning board's waiver authority, requiring that there be no adverse impact to public health, safety, and welfare. Because ultimately this is about public health, safety, and welfare. And in the context of subdivision review, the court has previously held that those types of elements, those types of ordinances that are primarily directed at police response, emergency access, things like that, are subdivision standards or in the nature of subdivision standards, and they don't constitute zoning. So I would say that would be the difference between a standard setback and the street standards in this instance.
What do we do when a standard appears in two parts of the ordinance, zoning and the subdivision?
So I think in this case, if the street standards had appeared within the zoning provisions of the land use code, not within the land use code itself, which is obviously where they are, but there's separate zoning regulations. If the street standards had been incorporated as a specific requirement for development within a specific zone, then this might fall within the ambit of, the York versus Town of Ogunquit case, where a standard was contained in two locations. But here, what we're really talking about is a municipality that has chosen to organize its land use code and zoning provisions under a single title or under a single area within its ordinances. And I don't think it would be appropriate to penalize it for doing so where there's a subset of, zoning regulations and then general performance standards.
Thank you, counsel.
Thank you.
Attorney Federle?
Thank you very much, Your Honor, and members of the court. May it please the court, I'm Tom Federle. I'm here on behalf of Ann and Chip Andrews. The court has raised a threshold issue of the court's jurisdiction. The court's jurisdiction is statutory. If you don't have it, you don't have it. If the town misspoke regarding it, that's really not relevant to whether the court has statutory jurisdiction.
Well, let's look at Freeport versus Greenlaw and Seidler versus Board of Psychologists, one in 80C and one in 80B, where we ruled that if the town doesn't say that you have a right to appeal and how to appeal it, that the statute of limitations is told. We have the authority to toll a statute of limitations. And shouldn't the same rule apply if the town misleads what the appeal time is, as opposed to not telling the aggrieved parties what the time is?
This same court many years ago had a case, an 80B appeal, where the Superior Court failed to provide the written decision of the Superior Court to any of the parties in the proceeding. And as a result, the parties were unable to timely appeal that to this court. And this court held that, notwithstanding the inequity of it, jurisdiction is jurisdiction, and the court's jurisdiction is statutory in nature, and the court didn't have the authority in that case to grant an extension, even though all parties before the court were urging that out of fundamental fairness, because none of them had received the order, and therefore the appellant had no ability to timely appeal. So I think the jurisdictional question that's been raised is foundational for the court to grapple with. And I think it's a good rule that it be clear and that municipalities have the obligation to understand that rule and to make their ordinances consistent with that rule so that it doesn't become this court's burden of deciding when do we toll, when do we not toll. So from a public policy perspective, I urge that the court does look at the statutory authority and determine whether it still has jurisdiction over this matter. This case did not involve a core zoning requirement. It's outside of the definition that has been discussed, But it's not like Perkins, where it was dealing with street frontage, which is getting to the dimensional standards within a zone. Street frontage determines the size of your lot. Things like lot size, setbacks, street frontage, those are all core zoning. And core zoning should be the standard, because that's what is authorized for a Board of Appeals to review statutorily. And it's also, coincidentally or not, what almost every municipality that has a Board of Appeals has authorized its Board of Appeals to review. So in the case at bar, if this court were to conclude the street length waiver that was granted here is not a subdivision requirement that can be waived, but rather a zoning requirement that must be varied through the Board of Appeals, the Kittery Board of Appeals has no jurisdiction over it under the ordinances of the town that say the Board of Appeals can hear variance requests of core zoning. So, and it lists the core zoning, and it is reduction in dimensional requirements related to height, area, size of structure, yards, and open space. That is core zoning. And what that leaves is for planning boards to do the hard work that planning boards are asked to do, and occasionally, and not so rarely, a given circumstance justifies, rather than two 700-foot roads that would be allowable, let's allow one 1,400-foot road because it's more efficient use of the land, it avoids resources. That's just good planning. And right now, the planning board in Kittery has the authority to waive a road length requirement appropriately. If you rule that it doesn't, there's no recourse. We can't go to the Board of Appeals and ask for a variance because that Board of Appeals has no authority over that because it's not a core zoning requirement. So the result is a requirement, a technical road regulation becomes immutable. We can't get a waiver from the planning board. We can't get a variance from the Board of Appeals. So you've elevated this relatively minor technical requirement above the core zoning, all of which we could go to the Board of Appeals and get a variance. So it's an illogical result to follow the arguments of the appellant. This court isn't like Perkins. It isn't like York. In York, there was specific language that was adopted into the zoning ordinance that established the standard. Here, that didn't happen. There was reference to this technical manual, but that isn't tantamount to making the technical manual now zoning. In Sawyer, this court focused on what is the nature of the waiver, the requirement that was being waived. And there it was a building envelope requirement that was in the zoning ordinance, or in the land use ordinance, but it was a building envelope requirement that implicated dimensional requirements. And there the court said, that's more like a zoning. That's more like a zoning standard, not a subdivision standard.
Well, how do we apply something that's beyond a, I know it when I see it standard? So that there's predictability in which they can do and which they can't. What's the test?
I think it is that the definition of core zoning is dimensional, the dimensional requirements related within a given zone. And those dimensional requirements relate to setbacks, they relate to size of a structure that's allowed, minimum lot size, size of open space that might be required. Those are all dimensional and core zoning. I think it's wise to leave it to the court to analyze that, and before it gets to you, empower planning boards to analyze, is this waiver request in the nature of subdivision, or is it really in the nature of zoning? And if it's zoning, the planning board can't waive it. And then this court can review it and decide, did they get that right or wrong? That's better than finding a gotcha clause that, by reference to a technical standard, happens to be in a land use ordinance. We're going to just by fiat say, well, then that can't be waived because that disenfranchises your planning boards who are trying to work to
Thank you,
do
Counsel.
what they do. Thank you very much, Your Honors.
Attorney Turley.
Thank you, Your Honors. Briefly, I'd like to address a couple points. One is, in terms of the distinction between land use and zoning ordinance, I hope it's not lost on the court the argument we raised regarding the waiver of that position. So as we pointed out in our brief, when the town went to the Superior Court, the argument was actually that the Class 3 street standards were not general ordinance standards. That was the position they took. And then they interpreted York as an extension of this principle that if it was a general ordinance standard, it could not be waived. In the law court level, the town has taken the opposite position. It's now saying it is a general standard, and therefore, because of the definition of a zoning ordinance in the statute, it's not waivable. That issue was never presented to the Superior Court. We had no opportunity until our reply brief to even see it or know
You
it.
you briefed it. How did you not have an opportunity?
We did, Your Honor, and I will contest that when establishing something like waiver, I don't have to show prejudice. But even if I did, in terms of assessing the viability of our appeal, whether to pursue it, that's in part based on what arguments were
But
raised.
it's a question of the authority of the board to do something. So why can't you always argue about what the authority of the board is? That's a
Because-
legal question for us, right? It's de novo.
Sure, but even in cases, Your Honor, when you've considered matters de novo on Rule 80B appeals, you have not considered arguments not raised by parties before
So
the
when
Superior Court.
were they supposed to, in their decision, their planning board decision, they should say, and by the way, we have the authority to do this?
Sorry. No, Your Honor, I'm not suggesting that at all. I'm saying in the 80B cases,
You're saying they didn't raise it to the Superior Court?
correct. I'm not suggesting they had an obligation to somehow know that there would be an appeal and to raise it before themselves. I'm saying they never raised it before the Superior Court, and by doing that, waived the argument, and that the argument raised by the parties in interest about core versus
Well,
technical.
then why did the Superior Court rule on this basis?
I did not read the Superior Court order, Your Honor, to rule on the basis of defining zoning. How I read it was they thought the Superior Court's position was that this was part of the subdivision ordinance, and therefore it was waivable.
Yes.
Right, but that wasn't because it wasn't a zoning ordinance under the statute as defined by the land use regulation statute. That wasn't the position taken by the Superior Court. Just lastly and briefly, as we put in our brief, if the test is not just things that are literally in subdivision ordinances, but anything in the nature of a subdivision ordinance, I think that is highly problematic. Both because it provides applicants no notice of when they have to seek a waiver versus a variance, and secondly, because it provides planning boards no guidance as to how to deal with when there's a variance versus a waiver. We also dispute the idea that somehow, especially in Worcester, that boards of appeals do not have jurisdiction over something like this issue, that somehow if the court rules in favor of my client, they will be out of luck and are unable to pursue any remedy of any kind regarding these road standards. They could certainly apply for a variance from the road standards. That's a position we've taken with the court. And if they meet the criteria in 4353, they could receive a variance. Thank you, Your Honors.
Counsel. Thank you. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, we will be in recess on this matter.
All right.
And good afternoon. You can be seated. The matter before the court is Montagu, Reid, Hankin versus Sarah Sewall et al. On both sides. This is BCD 25259. It appears counsel are present. I'm assuming you are ready to proceed. We're being streamed on the web, both by audio and by video. Before we begin the argument, I would ask that the attorneys who are arguing in this matter introduce themselves for the record, and starting with the appellant.
Emily Arvizu on behalf of Sarah Sewall and Thomas Conroy.
Good afternoon, Your Honor. It's Elizabeth Germani for the Appellees, Reid and Bondi Hankin, the Lee Family Corp. Et al. Yes, there's a
Et
large
al.
group.
Is fine.
Yes, Your Honor.
And with that then, Attorney Arvizu would be happy to hear your argument this afternoon.
Good afternoon, and may it please the court. This appeal centers on the use of Navy Road, a private dirt road located within a small, close-knit community along Maine's coast. Your Honors, this court should grant appellant's appeal and instruct the lower court to reverse its granting of prescriptive rights for all appellee's lots for the following 3 reasons. First, the trial court erred as a matter of law when it improperly shifted the burden to defendants to prove an absence of adversity by establishing sufficiently close familial ties, thereby discharging claimants of their heightened burden of proving actual adversity and notice. The trial court further erred by analyzing the familial relationships of the present-day owners as opposed to the owners during the prescriptive period. Second, the trial court erred as a matter of law when it recognized prescriptive rights benefiting undeveloped lots 9-2 and 9-3 when the evidence was insufficient to support the court's express findings regarding continuous use. The court further erred in concluding that a future change to residential use would be within the scope of those prescriptive rights when it required the court to consider hypothetical facts unsupported by the evidence. And lastly, the trial court erred as a matter of law when it treated lots 5 and 11 as one singular GCI parcel, despite there being separate and distinct parcels, and their use of Navy Road to access those parcels being factually distinct.
I see that the green light is on. You've talked about the improper shift of burden, but in the decision, didn't the judge basically say, and even if the burden didn't shift, I would still find that the burden was met to show that the use was adverse?
Yes, so for some of the lots, I believe the court applied the presumption of adversity and declined to make a finding of actual adversity. But yes.
For lots 9-2 and 9-3?
Yes.
But for any of the other lots, was there a finding of actual adversity regardless of the burden shift?
Yes, Your Honor, but there was no finding regarding actual notice. And this court in Andrikaitis v. White set out that when the properties, the dominant and servient estates, are owned by the same family during the prescriptive period, the claimants are held to a higher burden, which requires proof of actual adversity and actual notice.
So are we going to fight over what family means as opposed to fighting over the actual elements of adverse possession? I mean, shouldn't we really just be focusing on the actual elements as opposed to how we want to define family?
Well, so under Andrikaitis and Hamlin, this court has set out that there's this presumption of permission anytime the properties are owned within the same family. This court hasn't stated, how distant those familial relationships stretch out, but the family relationships that were at issue here during the prescriptive period, to the extent that you can determine what the prescriptive periods were, these were, sisters-in-law, first cousins, an aunt, and 2 nieces. All of those are family relationships that fall well within the precedent that this court has set in Androckides and
Can we,
Hamlin.
sorry to interrupt, go back to the court's alternate findings of adversity in this case? So you're suggesting that Hamlin and Androckides stand for the proposition that the burden to show adversity is higher than in a typical prescriptive easement case? Is that how you read those cases?
Yes, Your Honor.
And so what do you think is required that wasn't found by the court here?
So what's set out in those cases is that once the family exception is applied, then the claimants are held to this burden of showing actual adversity as well as actual notice.
And what does that mean to you? And have we said what that means?
It's not entirely clear what constitutes actual notice, but this court cited to Powell on property in Androckides and said, let's see, sorry, one second. So this presumption of familial permission applies unless the landowner is reasonably entitled to regard the use as permissive unless specifically informed of the contrary fact. And so I read that to say that there would need to be an actual communication to the survey and estate owner, which is a family member, saying, you know, at this point, we are no longer using it in the permissive way that has been used.
But that assumes they thought they were using it because of permission to begin with. I mean, the whole point of claim of right and adversity is that I feel I have the right to do it and I don't need your permission.
Yes, and I think this case actually presents, you know, a decent example of that. The road was used in common, you know, for a number of years, and it wasn't until one of the dominant estate owners actually came to our clients and said, you know, I'm intending to renovate my house and, you know, make changes to the road, and that's really what instigated this.
Well, I understand that's what instigated, but the whole point I mean, the notice that's required for an ad is that it be actual, open, notorious. In other words, that one should presume that they're knowing to do it, that they're doing it, right? Isn't that what we're talking about? You don't expect, if I'm using my neighbor's land in order to have a claim of by adverse possession, I don't have to say, by the way, I'm going to keep using your land until I acquire it by adverse possession. I mean, that's not what happens, and nor have we ever required such a thing.
Yes, that's correct in the context of where you have two strangers, essentially.
Well, even with
but in the
family
context of the family, what this court has said in previous decisions is that there is something heightened required, and it has said what's required is both actual adversity and actual notice, because the law infers.
Absent evidence to the contrary, the law will infer the comings and goings of family members across property owned within the family are by accommodation or permission and do not have the requisite adversity to support imposition of a prescriptive easement.
Yes.
And that the reason for that is it gets mushy, right? When it's family. But it doesn't, there's no requirement that they like serve a notice on the other saying, oh, by the way, we're now claiming it as opposed to not doing it by permission.
Yes, I think so. In that same case, in paragraph 22, it says that, you know, in the context of family, that the claimant can't rely on the presumption and instead bears the burden of proving by a preponderance of the evidence that she used the land under a claim of right in a manner adverse to the owner, which requires proof of adversity and actual notice to the true owner. So I read that as being different than the general showing of adversity. Because this court has imposed in there this requirement of adversity and notice.
So you're suggesting there's a notice requirement as between family members that doesn't exist as between strangers?
Yes. Yes, Your Honor.
Could that mean simply actual awareness of the use as opposed to some sort of communication?
I mean, so I interpret that to mean an actual communication, because if it were simply awareness, that would fall within the regular, you know, elements of prescriptive easement. I mean, it would fall within the
But isn't
knowledge
that
and
problematic
acquiescence.
if in fact, I mean, if in fact the person is using the easement, the road, the right-of-way, whatever it is that they're using, under what they believe to be claim of right? Let's assume they've got a deed that says, you have the right to use this. Excuse me, but it turns out there's a defect in the chain, so there never really was one, okay? I mean, they're doing it because they think they have a deeded right to do it, regardless of the family relationship. Why would they then say to the other member of the family, oh, by the way?
Yes, so this court has said that, the subjective intent of the claimant is irrelevant to the inquiry. But
So what we're
as-
looking at is what the property owner would think, and when they're family, there's a presumption that you're letting them use their property, so there has to be a higher burden of proof to show that they're asking for a legal right that's taking away your property right.
Yes, essentially it's noticed that the survey and estate owners' property rights are now in jeopardy, whereas previously they were permitted to infer that the comings and goings were by permission.
Can I ask you, none of this discussion applies to the Hankins in Lot 7, correct? Because they were not family, and the court found that the presumption did apply in that case, is that right?
Yes, I believe that's right.
All right, so is there any reason that you argue that we should vacate the findings as to Lot 7?
So our position is that this presents an opportunity to adopt the friendly neighbor exception, which has been recognized in other jurisdictions. And to the extent that this court does formally adopt that exception, then it would certainly apply in the case of the Hankins.
And you'd be seeking a remand for the court to consider in the first instance whether the Hankins were, or their predecessors were friendly neighbors? Is that what you'd be asking for?
No, I don't believe so. The trial court made specific findings regarding the neighborly relationships of all of the parties, and so there wouldn't necessarily be need to remand it for further fact-finding on that issue.
So you think there's sufficient facts in this record for us to find that the friendly neighbor exception applied in this case?
Yes, assuming that this court decided
And what
to
are those
adopt it.
facts that you would rely on?
Yeah, so in this case, all of these neighbors going back generations, they worked together to essentially exclude anyone else who was not one of the small pointer landowners. And so they put gates up across the road to deter others from using the road.
Wouldn't we be looking at, though, their relationship vis-a-vis each other and whether, your clients were allowing other people to use their portion of the road out of neighborly friendliness? Is it really relevant that they were excluding folks who clearly didn't own any property on the peninsula?
Yeah, so in other jurisdictions where this exception has been adopted, there's a number of different factors that they look at. They look at the relationships among the actual parties, and here there's sufficient evidence in the record showing that these were very friendly neighbors. They spent a lot of time together. They worked together and put together a summer school for the children. They celebrated birthdays and holidays and everything together. And then another factor that other courts have looked at is whether the use that's being made is consistent with the use by the dominant estate is consistent with the use being made by the servient estate. So for example, in cases where there's a private road that's used by the servient estate owners to access their own residence, if it's also being used by dominant estate owners, that would be considered consistent and therefore fall within the exception as well. And I think the other, I'm sorry.
Well, your red light's
Your
on.
red light is
Oh,
on.
I'm sorry. Thank you.
Thank you.
I'm ready when the court is.
If you want to use it, you can lean it in front of the podium or something, I don't know.
Well, I'm going to do whatever you tell me to do, Judge. It's big.
We could see it if you just leaned it against your podium, I think,
Okay.
on the front, unless you were trying to
Thank you, Your Honor.
demonstrate, in which case you can't really do it, but,
I'm pretty short to maneuver these.
okay. Matt, does that work? That's the problem.
What if I moved it down? I did, I fixed it.
All right, go ahead and speak.
Is that okay? No. Okay. Do you have- Yes. Can you hear me? Okay.
Because of the video, I would ask that you stay toward the podium, though.
Yes. May it please the court, counsel, this case is about this court doing equity to the parties who have lived on Small Point for their entire lives. They have been there for as long as any of them can remember. Many of my clients are now in their, I think all of them actually, are in their 70s. They don't remember a time where they weren't going to Small Point on a regular basis. I have this demonstrative before the court because I want the court to put into context how the legal issues really play out in the context of the properties on Small Point and the people who are actually using them. Where we are in this case procedurally is that the only people who can stand in the way of my clients accessing their own property, not a beach owned by somebody else, but their own land, is Ms. Sewall and Mr. Conroy, who own only one half the width of a very narrow, single-lane dirt road, and they only own a couple of 100 feet of Navy Road, which is more than a mile long. Everybody else in this case, all of whom were named as parties, either defendants or parties in interest, has either not contested my client's rights to use the length of Navy Road, or if they did contest it, they haven't pursued it. If they initially appeared and contested, they haven't pursued it. So everyone else has either agreed with the contention that my clients have a right to get to their own properties along the entire width of Navy Road, or they have waived any rights to appeal the decision, the right decision, by the way, of the trial court. This is Navy Road. Navy Road comes down, and this is a little bit misleading because it actually goes very close to the pond. And it's a little hard to see, and the court has it in the most recent iteration of this is on the last page of the appendix. That is a 2021 pictorial description of where all these parcels lie, and it shows an overlay of Navy Road on it. And when the court has an opportunity to look at that, what you'll see is that this area right at the upper, and I'm just going to say easterly, so the northeasterly corner of the pond, which is the pond here shown on the diagram, is the only area that's in dispute. The reason that that is important to this court is Judge McKeon found, after hearing 5 days of testimony and looking at over 150 exhibits, almost all of which was stipulated, that it was very clear that there was a road that existed here for a very long time, meaning a road that existed north of the Sewall Conroy property going to the pond for a very long time. And I don't remember the exact, he said long before 1960 is the way he phrased it, so I can't tell you when the starting date was that he found it, but that's what he said. 1960 is important because that's when the Navy improved the road that had already been there. And we know there had been a road already been there, that had already been there because there was undisputed testimony from Sally Comey, Reid Hankin, Kyalani Lee, and Kimmy Lee Alexander that they remember walking that road in the same spot and in the same configuration.
Counsel, I'm going to stop you because I'm looking at page 54 of the appendix, and Justice McKeon said there's insufficient evidence for the court to characterize a consistently existing road south of the parcel prior to 1960 that was any more than a path or perhaps a cart path. So I did not understand.
So
Okay.
that's,
So-
Your Honor, he said south of the pond, and that's why I wanted the demonstrative, because what he's talking about is south of the pond that goes to the point. This road goes all the way down to the point, all the way down.
what's
And
the
some of my
consequence of
clients
the-
own properties down here.
What's the consequence of the road north of the pond that existed prior to 1960 in your view?
I'm sorry, what is the what of it?
What is the consequence? Because this is not, I don't read what you're telling me now as the basis for the trial court's decision. So what is the significance of?
The significance is that I think it's important that the court understand that everyone else has agreed that my clients have the right to use this road.
That's what was the Woods Road before it was the Navy
It was the
Road?
Woods Road. It's also referred to in some deeds as an ice hauling road.
So
But-
that in referring, as Justice Lopez said, to page 54 of the appendix, it looks like he's saying there was a Woods Road, but that only went as far as that corner of the pond, and there's no question that was there before, but what he's finding wasn't is below that.
Is south of the pond,
Okay.
which doesn't really matter to anything we're doing today, which is why I started where I did, because the Cuthberts are right here. They're the next people south of Sarah Sewall and Thomas Conroy. If we get to the Cuthberts, my clients are all set, because the Cuthberts have not disputed their right to use Navy Road. And so what the court found explicitly, based on a lot of evidence that was presented, was that there has been a road there since long before 1960 that gets people to the pond.
But doesn't he still have to find that each of the lot owners south of that point have the right to use the road? In other words, you can't just say one does, therefore everybody does. Doesn't he have to address it lot by lot?
Well, the judge did address it lot by lot, but in terms of what I've been talking about this afternoon, everyone's already agreed, Your Honor. I mean, they've either they agreed from the beginning, or they've now waived any contest to what the trial court ruled.
Well, everyone except for the defendants.
Except for the defendants, right, which gets us to the
not
point of, we're talking about it's probably 5 or 6 feet of width of a 10 to 12 foot wide road over a very short segment of a road that's more than a mile long.
When we understand that, but I'm not sure that that has anything to do, the size of
Well-
it doesn't have a lot to do with the issues.
So, well, when the court's doing equity, I think, and I may be wrong, you're the court, but putting it into context about the equitable principles here and how that interplays with these prescriptive easements, this prescriptive easement argument is important because it has an impact on people. I wanted to also raise a couple of comments. The analysis that the trial court undertook in this case is exactly the analysis that counsel for the defendants asked the court to undertake. If the court were to look at page 173 of the last day of the transcript, there is a description in there from Joe Talbot of what he said, and this is what he said. He said they were talking about he said the totality of the facts and circumstances, and then skipping down, he says, so in no way, Your Honor, are we arguing anytime there's any distant family relationship between the parties that the presumption goes away. It's talking about the presumption of adversity. But what we're arguing in this case is that the unique facts and circumstances of how the Small Point community arose through the generations, how property rights were treated among generations, how the community was kind of a joint effort, if you take that in totality, it at least provides an explanation as to why adversity shouldn't be presumed. The court did that. And now, before this court, on appeal, what the defendants are claiming is the court should not have done this. What they should have done, according to the defendants, is said, well, there's a common drop of blood somewhere between some of these people, and that's enough.
Can I direct you, though, to lots 9-2 and 9-3? Did the court find adversity regardless of the presumption with regard to those two lots?
Well, what the court said and addressed this in response to the motion for additional findings, and I put that in quotes because, frankly, the motion for additional findings of fact wasn't for additional findings of fact. It was really should have been called a motion for reconsideration. But in response to that, what the court said was, yes, I did look at that. It was a closer call with respect to those two lots. But what he was talking about was a closer call with respect to the continuous use issue. But he found that there was continuous use, and that's and essentially what he ruled. And frankly, none of these other elements were disputed. By the way, there was a brief filed by the defendants. Defendants proposed findings of fact and conclusions of law. It was filed on December 30th of 2024. And in their proposed findings of fact, they proposed GCI and LFC and their predecessors and title have continuously used Navy Road access Lot 6 for at least 20 years. Such continuous use has included pedestrian and vehicular access to Lot 6. However, Lot 6 has been placed under a conservation easement. And what they were complaining about was off-season usage. There was never a dispute here that there was continuous use by these lot owners that had houses on their lots.
But regarding, going back to lots 9-2 and 9-3, though, you would agree, right, that the court did not find adversity. In other words, if the presumption were to shift, the court said there was insufficient information for it to make a finding. So there was no alternate finding as to those two lots. Is that correct?
My recollection of what the court ruled in response to the motion for additional findings, Your Honor, was that it was a closer call.
Well, I thought that was on the issue of whether the use was continuous, but in the decision itself, and I'm looking at Appendix 66 to 67, he says that the relationship was not close enough to assume the permission, therefore adversity is presumed, and they did not rebut that, and that the court's finding of a prescriptive use to access these two lots depends on the court's finding that the family relationship was insufficient to shift the burden on adversity.
And then what he did was he dropped a footnote, and he said, if it was necessary to reach the issue to decide the case, the court would request additional briefing and argument from the parties, because the court decides the case applying the...
But if he's saying that it's additional briefing and argument, don't we then, shouldn't we decide it based on the record in front of us? In other words, if we think that there had to be, adversity was not presumed, what do we do with it?
If adversity was not presumed?
Should not have been presumed on this record for those two lots I'm just talking about now, 9-2 and 9-3.
So there are a number of reasons why the court should find that there was adversity that would overcome any kind of presumption of permission.
I understand that, but he didn't. He said it depends on the presumption of adversity, not an actual.
But he didn't say he didn't either. He said, okay, I'm relying on the presumption for this, and I would need more information if that were not the standard. But, Your Honor, we should talk about the alleged family connection here. The Edges didn't even know these people. The Hankins didn't even know these people. So we're talking about, these are not siblings, these are not even first cousins. These are distant cousins who did not know each other. The Hankins didn't even meet Sarah and Thomas until 2021.
So what should our test be for application of the family exception?
I'm sorry?
What should our test be for family exception application?
And to be clear, it's not an exception to whether there can be...
To the presumption.
It's a burden-shifting presumption, right?
It's a burden-shifting presumption, it is, but I think that the court, I think it's a factor, Your Honor. The family connection is a factor. When you look at the Androckides case, if you look at the quality of what they were doing, this was people who were crossing a lawn, if I read the case correctly, who it started with siblings and went to their children, to first cousins. They were crossing the lawn to visit one another. There was evidence in the record that they were close. They spent a lot of time together. There are none of those facts here. There are none of those facts here. Kailani Lee testified that she really didn't get, and Sarah Sewall admitted this, they really didn't get to know each other until they were much older. So, and also, 9-2 and 9...
define it not based on the specifics of the family relationship, in other words, whether they're sisters, whether they're uncles, whether they're third cousins 6 times removed, but rather based on the nature of the relationship.
I think it's both. I think it's both. I mean, are we going to stand here and say that every siblings get along? I mean, we all know that that's not the case. You probably see cases about that all the time. I don't think that's the analysis. And these lots, frankly, were part of Camilla Sewell Edge's property.
Can I ask you, go ahead.
We say it's a fact-specific inquiry, but we don't have any guidance. It's totally up to the finder of fact, both on the family use exception and also on the friendly neighbor exception. It seems like a very amorphous, very generalized concept. Should we promulgate rules or bright lines that we can do, or are we stuck with this, it's a fact-specific inquiry?
I think it would be very difficult to draw the bright line, Your Honor. I'm not exactly sure how that would happen. If you said, you know, every sibling you're going to have a presumed permission among siblings. I mean, how many family matters have we all seen in our careers where siblings don't speak to each other? Is that enough?
Thank you, counsel.
Thank you.
Attorney Arvizu, I think you reserved 2 minutes for rebuttal. Did she? Okay.
I just wanted to address a couple of points, hopefully very quickly. On the family exception, I think one of the primary issues here with the way that the trial court analyzed whether it applied or not was, again, looking at the relationships among the current owners. The inquiry really is, what were the family relationships of the owners during the alleged prescriptive period? And so
Which
to the
may have
extent...
changed over time.
Sorry?
Which may have changed over time.
Yes. So, I mean, if we're going back to the 1960s, we're talking about ownership between sisters-in-law and siblings. You know, so to the extent that we're talking about the current day...
But it wasn't necessary to go back to the 1960s for the prescriptive period that the judge found, right?
Well, for some of them, he found the prescriptive period to be like 1971 and then 20 years.
1982 to 2002 or 2001 to 2021, I think, are the 2 different prescriptive periods.
Right.
It's lots 9, 2, and 3 where there's a mismatch. Is that your argument?
Yes, and so, you know, we're looking at the current owners and their family relationships, but actually during that earlier prescriptive period, the family relationships would have been either sisters-in-law or an aunt and a niece. So it's well within, you know, what this court has applied the family exception to in Androckides, which was also between siblings and cousins.
On lots 5 and 11, I know you've made the argument that the court didn't separate out the analysis. Can we infer from the way the court did this that it was sort of making the same fact finding as to both lots because of the ownership history, or would that not be proper in your view?
Well, our position is that the facts for Lot 11 are completely distinct from the facts for Lot 5. The court talks about the upper house as being the primary I guess, the focus of the access for those lots. upper house is located on GCI Lot 5. There's no residences or anything on Lot 11, so it's a completely different fact.
Thank you, counsel.
Thank you.
Thank you. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. Also, it's my understanding that, counsel, you argued at a high school, but not in this court, and we, of course, do not consider a high school argument to be your first appearance in front of this court. So as is our custom, we invite counsel to come back to the conference room and take the greetings of the court. We'll see you there.
All right. All persons having any further to do before the Honorable Justice of the Court, sitting as a law court, agents depart will be there attending here at 9:10 tomorrow morning, and this court now stands adjourned. I'll take the name of this honorable court.